Yes.
My Lords, can I very briefly give you some references that I skipped over by mistake on the issue of whether the investment is seen as what is put in by the investor or whether it is the results of what is put in, which is our case, the assets that are acquired. This matter was considered by Mr. Justice Butcher in two cases where he came to different conclusions on different wording. In the first case, PAO Tatneft, he considered that the investment under the treaty was confined to the assets such as shares acquired as a result of the resources put in by the investor. That's at paragraph 64 to 66, authorities 43887. Then in Dayani, he thought that the investment under the treaty extended also to what the investor put in. So both what the investor put in by way of money and also the results of that, what was put in. That is at paragraph 46, authorities 44, page 915. That's, as I said, it's on different treaty wording. Relevantly, we would say in this case, because there the treaty expressly referred to as examples money in a way that this case does not. Also, if I could just give you one more reference, which is to an investment treaty case considering this issue, that is Inmaris and Ukraine, which we say is analogous to the current situation because it's about cash being used to acquire a given asset, and that's at authorities tab 19, 266, paragraph 99, and at paragraph 101 in particular, it identifies the payments as contributions made to obtain the investment, not the qualifying asset.
Yes. Thank you very much. Yes, Mr. Starr.
My Lords, good afternoon. I am addressing ground 2 on the meaning and application of the term measure in this treaty. This ground is fought on the basis that the court accepts that the relevant capital I investment is the shares of RAKIA in ANRAK. If the correct analysis is that RAKIA's investment extended to the BSA, then India accepts that there was a direct application of GOM 44 to the BSA, and that there was therefore a measure applied directly to RAKIA's investment. Mr. Wordsworth has dealt with that point regarding the extent of RAKIA's investment. I will then address the situation where RAKIA's investment was only the shares. The present ground therefore asks whether, on a proper construction of the treaty, and Article 1.8 in particular, GOM 44 was a measure applied directly to the shares. As we've heard this morning, for these purposes, it makes no difference whether the investment was also in the pledge or share contribution monies, and neither side has suggested that it would under ground 2. Now, just by way of outline of what I would like to do this afternoon, so that you can see where I'm going, is firstly briefly to summarise our position on ground 2, and secondly to look at the ordinary meaning of Article 1.8. Then, in light of the discussion this morning, I would like to address some of the questions that were raised and concerns that were raised by the court this morning in respect of the scheme of the treaty and how it works, before considering where we say the judge erred in his approach and considering RAKIA's respondent's notice grounds. So, my lords, by way of summary of our position, obviously the key wording is in the definition of measure in Article 1.8, and that's in core tab 14, page 140. In summary, our case is very simple. In order to establish Article 10 jurisdiction, the definition of measure in Article 1.8 requires the direct application of binding state action to the investment. That is, to the asset that was invested by the investor. When read with the definition of investment in Article 1, that binding action will be telling its subject or recipient what it is required to do or what it is not permitted to do in respect of an asset invested in India by the Emirati investor. This also means that binding state action that was applied directly to an asset that was not invested by the claimant investor is not a measure. So if, as here, the asset invested by the claimant investor is a shareholding in a local company, RAKIA, as that claimant, must show that the binding action underlying the dispute was applied directly to those shares. And we submit RAKIA cannot do that because the only asset to which the binding action was applied directly was to the contract. As a matter of ordinary language, we say, an order requiring a state mining company to end a contract with its Indian counterparty is binding action applied directly to that contract, not to the shareholding in the Indian company held by the Emirati investor. So if, as ground 2 presumes, the BSA is held not to be RAKIA's investment, then RAKIA cannot establish a measure.
What about to the business of ANRAK?
Well, my lord, absolutely, and we'll come on to consider the business of ANRAK, but to put it simply, in a case in which the business of ANRAK is impacted or affected by governmental action, executive action even, that doesn't count. That's our simple proposition. Doesn't count. And we don't shy away from that, my lord. I'll try to explain why this afternoon.
Forgive me, just picking up, you're saying that state action was only directed at the contract, but that's a very, very narrow view of what it's directed at. They presumably don't care tuppence about a particular contract. What they care about is that that bauxite isn't mined and transmitted to the refinery. I mean, it's concerned about the whole business, isn't it?
Well, Mother, with respect, we need to take it in stages because there's quite a lot to unpack in that question. So, first of all, the state action, as the judge found, was applied directly to the contract. That's the finding in the judgment, paragraph 100. Secondly, is it a very, very narrow view of what it's directed at? We would respectfully say no. That is what GOM 44, when one reads it, is directed at, and I can take your lordship to show that. But in a sense, underlying that, our point, and we don't, as I say, shy away from that, is so what? That's the scheme that the treaty envisages in order to access Article 10 arbitration. I'll, as I say, seek to make that point.
No, but the question is that the way to read it?
Absolutely, my lord. And I think in order to understand if that's the way to read it, we need to begin with the structure and scheme of the treaty and Article 1.8 and see how it all...
If you read, just to be clear, if you read it so that we're looking at investment is only shares and an action directly applicable only relates to on a very basis to a contract, which is direction is taken in relation to against, then you're completely negating the whole thing.
Well, again, my lord, I'd have to disagree with you on the premise underlying that, which is the suggestion that we're negating the whole thing rather depends on what the whole thing is seeking to do. And what, as I say, if we take a step back...
We're meant to look at treaties on a fairly purposive basis, including looking at the the purpose of the treaty as in particular derived from its own terms?
Well, absolutely, my lord. Absolutely. We are meant to look at it on a purposive basis derived from its own terms. And when we do that, we will see this is not like other treaties. This is a particular and special treaty. It is particular both in terms of the wording, which your lordship has pointed to, but also in the circumstances in which it's entered. So as I say, this is a special case. This is not, one cannot come to this appeal with respect, and I'll insert a jury point, encumbered by previous cases of what treaties are meant to do or not meant to do.
No, we come to it through the Vienna Convention,
Absolutely,
which tells us to look at, by virtue of Article 32.
31 and 32.
31 and 32, so look at the language.
Okay, so let's turn to that then, in terms of the language. So 4 introductory points. Firstly, on the language, we respectfully submit that our approach makes the best sense of the ordinary meaning of the defined term measure, respecting the Vienna scheme, as compared to the approach in the judgment or the respondent's notice. Secondly, and is consistent with and respects the context of this particular treaty, in particular its identification of a capital M measure as part and parcel of the jurisdictional offer to investors. That's the Article 10.2 point. And that's what really makes this treaty unique and special, we say. It is really, really critical for the court, as no doubt you've seen in our submissions, to appreciate that. If I take, for example, my lordship's Monday afternoon example of this Monday morning, imagine a situation in which there's an investment made through money contributed to the company in exchange for a promise or in exchange for shares. Well, if Article 10.2 does what we say it does what the tribunal found, does what Mr. Landau considered it did, it means that in that example, the state could, by legislative action or judicial action, take that promise or take the shares themselves without any recourse to investor-state arbitration. So the protection offered deliberately, structurally in the treaty, the protection offered for investors via investor-state arbitration is incredibly circumscribed, deliberately so. That is the starting point through which one then needs to consider what is and is not a purposive interpretation. The third point...
So were you making that point by contrasting legislative and executive action?
My lord, I was. So
I understand, I just want to make sure I'd understood.
Yeah, legislative and judicial is outside the scope of the offer to arbitrate, as you saw in Article 10.2. It is only executive action in respect of a measure that can count as part of the offer made to investors to arbitrate. The third point is that India's approach to Article 1.8 is actually a far more straightforward and certain test to apply than the respondent's current proposal. The fourth point is that this analysis still protects RAKIA's minority shareholding consistent with the scheme of the treaty. Firstly, by providing for investor-state arbitration in circumstances where binding executive action is taken directly against that shareholding or against the investor's rights as shareholder. And second, through the wide state-to-state arbitration clause. Now, we'll come on to it, but one of the observations made this morning was, well, there aren't that many cases that one can envisage of executive action taken directly against the shares. We would respectfully make two initial observations to that. First of all, it's not necessarily the case, because one can imagine a wide swathe of executive action taken directly against the shares in terms of straight-out attempted expropriation, interference with voting rights, interference with an accrued right to dividends, and so on. So there is a measure of protection available to shareholders, point one. Point two is actually, obviously, we are looking here at a shareholding scenario, but that isn't the only question before the court, in a sense. What you need to come to the conclusion that your lordships need to come to is what the correct construction of 1.8 is, which, as my lord Justice Miles pointed out, it doesn't just apply to shares, it applies to every investment contemplated by the treaty. And we say that's significant, as I'll come on to. And the third point is, even if the court was to consider, well, this is a very, very narrow scope of protection where an executive targets the shareholder with his rights qua shareholder, again, and we don't shy away from this, we say that, so what? That is actually the deal that is reflected by this treaty. As we shall see, RAKIA's position on this appeal, on the other hand, does not actually support the approach taken by the judge. It proffers an alternative test for a measure of direct nexus, which does not use the actual wording in Article 1.8, and it cannot identify how, even on its chosen test, direct nexus, GOM 44 was applied directly to the shares. Instead, you will notice, my lordships, RAKIA has to do one of two things to show a direct nexus between GOM 44 and the shares. How does it bridge the gap? It tries to do it through two ways. First is to expand its investment into the investment project as a whole, which it cannot do for the reasons explained in ground 1, but that point creeps into ground 2. And secondly, the alternative or different way of looking at it is to treat the test as satisfied when binding action is applied to an asset A, here the BSA, which affects the value of asset B, here its shares in ANRAK. But just picking up on Lord Justice Phillips' point, there is no basis for this applying Vienna Convention principles for the simple reason that the term applied directly to does not have the same meaning as directly affecting or impacting value. Now, my lords, before we get on to the scheme of the treaty, I want to first, if I may, consider the ordinary meaning of the words in the definition of measure. And it's key to do this before we start considering the consequences of each party's position, because we say it's the best indication of what the contracting parties had in mind. So you'll have it hopefully at tab 14 of the core at page 140. As it is in the definition section, an obvious point, but it's intended to apply wherever measures are referred to in the treaty. And as I've said, this wording is exceptional. Neither side have pointed to a treaty which uses the same wording in the same way. And therefore you are unlikely, with respect, to get much assistance from other cases dealing with other wording. Just if we can go through the component parts briefly. Measure means any form of binding action taken by a contracting party under any law, rule or regulation. So law, rule or regulation, the measure has to be an action taken by the state under one of those categories. In other words, it's a legally authorised action. That can be any form of binding action. The use of the term binding indicates that it is an order that must be complied with by its subject or recipient. The term any form is obviously very wide. It means we say that the test is a question of substance. There is binding action made with legal authority and applied directly to an investment, it will be a measure. And the form in which it takes does not matter, provided it's made with that authority. It can be a wide-ranging action or a specific and targeted action. And then the action must be applied directly to a capital I investment. Now, regarding the term investment, if one unpacks and inserts the definition of investment from Article 1.1 into this clause, as one should, that means that the binding action must be applied directly to the asset invested by the investor. What is the ordinary meaning of applied directly to here? We look at applied and directly to in turn. First, we submit that the choice by the parties of the term applied as the required link between the binding action and the investment is significant. It is a term that is used not only in this definition, but it is repeated in both Article 2.1 and 2.2 when addressing capital M measures. If binding action is being applied to an investment, it is telling the recipient of the order what it must do in respect of an asset invested by an Emirati investor in India. It indicates that the test is not whether the action is connected to or impacts or affects the investment. The parties could have chosen one of those words and to say that a binding action which impacted or affected the capital I investment was a measure. Indeed, where they intended for consideration to be given to the impact or effect of a capital M measure, they say so specifically in this treaty, and we'll see that in both Article 7.4 and Article 10.8 sub B, which Mr. Wordsworth took you to earlier, the limitation provision. But they do not do so here. So they distinguish between a measure, capital M, and the impact or effect of said measure. So that's applied. Then we have directly to. The test of a measure is not simply whether the binding action is applied to the asset invested by the investor. Instead, it asks whether the action is applied directly to it. In India's submission, the ordinary meaning of the term directly to, when used in conjunction with the term applied, is to perform a narrowing function, to emphasize to the reader that the binding action must be applied to the very asset that has been invested by the investor. So, that means that cases where the binding action is applied to an asset other than the investor's asset do not count, and cases of indirect application to the asset invested by the investor do not count. So we say cases where the asset invested is impacted or affected by the binding action are not measures. That, in a nutshell, my lords, is our positive case on what measure means. And I thought it helpful to clear the ground on that before we look at the scheme of the treaty. If we can then consider that. My lords will have seen how Mr. Justice Knowles considered this and identified a concern that he had at paragraphs 116 and 117 of his Lordship's judgment. That's at core page 125, it's, tab 9. And at para 116, his Lordship identified his concern that the tribunal's approach would mean that a major form of investment structure fell outside the compass of the PIT without apparent reason for that choice. This would discourage investment in local Indian companies. And at para 117, his Lordship noted that it was possible for parties to intend that effect, but there is no explanation why they should or did with the BIT in this case, and he refers to the preamble. Now, we say with respect that the judge erred here in these passages, both in his diagnosis of a problem and in his proposed cure for it. Indeed, I note at the outset, my lords, that one irony of the judge's approach, which was to ask whether the measure was targeted at the investment, one irony of that approach is that if the goal was protection of shareholders in Indian companies, the approach in the judgment actually risks narrowing that protection considerably because it requires binding action to be targeted at a specific project, thus excluding from its scope generally applicable wider regulation that is nevertheless applied directly to Emirati investments. And you can see that in his analysis at 112 and 113. It says the result is a balance. One thing to include an offer to arbitrate that is addressed to executive action that does not apply more widely. It is another to do so where it would inhibit wider executive action. Now, India submits that there are a number of specific features of this treaty which indicate the judge's concern was misplaced. There are 5 points to draw to your attention. The first is the dislocation of the substantive rights granted in this treaty from the investor-state remedy. Dislocation sounds like a pejorative word, but I couldn't think of a better one. It's what happens in this context. This treaty does not link the provision of a substantive right with the provision of a coextensive remedy through investor-state arbitration. Instead, through the introduction of the term measure, it does not do so. It dislocates the substantive protections from the offer. If one looks at Article 10.1, for example, so core at page 147, if I could ask your lordships to consider that provision. So it's the introductory paragraph we say in Article 10, disputes arising between a contracting party and an investor, the other contracting party, in respect of an investment under this agreement shall be governed by this article. And in similar terms, you'll see Article 10.4. If Article 10.1 or 10.4 were the offer to arbitrate, it would mean that the substantive protections offered to an investment correlated with the offer of arbitration, because the substantive protections apply vis-à-vis investments, capital I. This is about disputes arising between an investor and a state in respect of his investment. But it is a structural feature of this treaty that through Articles 10.2 and 10.3, the obligations imposed on each party in respect of investments will not necessarily be enforceable by way of investor-state arbitration, unless a measure is taken by the state in respect of them, and an executive measure at that. I emphasise by way of investor-state arbitration, of course, because the state-to-state dispute resolution provision in Article 11 is not tied to the imposition of a measure. You'll see that at page 150, but applies far more widely to any dispute concerning the interpretation or application or execution of this agreement. Now, that dislocation also occurs partly through 10.2 and 10.3, but also because the substantive obligations themselves do not coincide with or apply to the occurrence of a measure. So if we see Article 5.1, for example, on page 142, this provision contains the central treaty obligation to ensure that investments are given fair and equitable treatment. An important treaty obligation, obviously, but the imposition of that obligation on the state is not specifically tied to any measure that the state might take. Instead, each contracting party, is under a general obligation to treat all investments fairly. So India has an obligation to treat all investments made by Emirati investors in its territory fairly, so on. But that is a substantive obligation which will not be enforceable under Article 10.2 unless there is a measure, capital M, taken against the investment. Now, many breaches of the FET obligation will coincide with the imposition of a measure, e.g. revoking a license in an unfair way or denying due process when reaching a decision regarding a foreign investment. But not all, and the obligation imposed on each state to act fairly is not limited to those occasions on which it imposes a measure. So the obligation imposed on each state to act fairly is not limited to those occasions on which it imposes a measure. We say that's significant. It was not intended that there would be full coextensive coverage, one hand substantive protection, on the other hand an offer to arbitrate. So that's our first...
Sorry, may I just ask you a question about the idea of state-to-state enforcement in that kind of circumstance? So, on your hypothesis, the investor wouldn't be able to bring that dispute unless it falls within 10.2, so it's a measure and it's an executive action. Could the other state bring proceedings in those circumstances, and could it claim compensation, for example?
So by the other state in your lordship's scenario, this would be the UAE?
Yeah.
Yes. So it would in respect of Article 11, there would be a dispute concerning, for example, the application of the agreement. One would seek to resolve that initially through consultations or other diplomatic channels. And then if that dispute has not been resolved within 6 months and so on, then you can bring a state-to-state. So moving backwards, a UAE would be able to bring a claim in respect of the treatment of its investor and for failure to apply the treaty properly in respect of that investor.
And claim damages or compensation? How would that work if the investor itself can't do it?
There's nothing to stop the state in our submission from claiming damages or compensation or restitution. It would depend upon the specific complaint at issue.
But that is a process over which the investor has no control, so it may be that for wider diplomatic reasons, the state of which the investor is a national chooses not to avail itself of Article 11, and the investor is then left high and dry.
Well, I would agree with the first part of the observation, my lord, which is in that situation they wouldn't be able to pursue the state. If the state hasn't pursued an Article 11 remedy and the investor has no control over that process, I would accept that. I would cavil with the description that the investor in that scenario would be left high and dry, in a sense, because it would depend upon the factual circumstances that we're looking at.
It has no remedy.
It would have no remedy
for
under
the
this.
loss which it has, let's assume, suffered.
Under this arrangement, that is correct. If the Article 10.2 offer does not cover the conduct complained of, and the state of that investor doesn't choose to exercise its Article 11 right, then yes, that's correct. But that is, as I say, that is not surprising as a proposition of international law. That is often the case, and it's not actually a concern we respectfully submit in the arrangements that we're looking at here. We do say that the width of the state-to-state provision, notwithstanding that the investor doesn't have control over that process, is important when considering the balance in the treaty as a whole.
How does that fit with the aspirations in the recitals to the treaty?
Because it provides, there's no obligation to provide a remedy of state-to-state arbitration. So it fits perfectly well with it in the sense that it is providing another mechanism, albeit through the state, for the vindication of an investor's rights, protections in relation to its investment. But one has to be a little bit careful in our submission about putting significant weight on the preambular wording here. That preamble tells you, in a sense, as we know, what the parties intend to do, but the mechanism for that intention was obviously through the specific terms that they agreed on in the treaty. And so it doesn't actually give you the answer, as it were, as to what the end result should be. It's not the case that in every case, if it would be better protection for an investor in respect to this investment, that must be the result. And Mr. Wordsworth took you to the EAIB and Slovakia case, I think at paragraph 385, which made that point. Mm-hmm. That's the first point we were making in respect of the dislocation of substantive protection and the offer to arbitrate. The second point, shortly, is the point I've already made, so I won't dwell on it, but it's that Article 10.2 is restricted to executive measures. And even if there had been a measure applied to an investment, so it's a directly applicable form of binding action. If it was a legislative or judicial measure, that falls outside the scope of 10.2. And that means that even where there is a clear measure, such as a legislative decree or a judicial order, which simply takes away or expropriates a foreign investor's assets, that binding action cannot be the subject of arbitration under Article 10.2. Now, if one considers the implications of this for RAKIA's argument and for the judge's concern that the treaty must have been intended to protect an investment in the form of a shareholding in a local company, the restrictive scope of Article 10 means that a legislative or judicial decree that simply took RAKIA's 13% or so shares or subjected them to a compulsory sale, for example, would not be amenable to investor-state arbitration under Article 10. That is baked into the structure of the treaty, and it's critical to appreciate because it forms the correct context for considering the extent to which the treaty was intended to provide protection via investor-state arbitration. The reality is that the definition of measures, combined with the limited offer in Article 10.2, deliberately excludes large swathes of state conduct, much of which could negatively affect a minority shareholding from the scope of the offer to arbitrate. And that's why we say, with respect, that the judge went wrong in diagnosing a problem with the tribunal's approach to minority shareholder protection. The third point is the express exclusion from the scope, the express exclusion from the scope of the most favoured nation provision of jurisdictional matters. I'm sorry, that's something of a mouthful. Let me unpack that. The restrictive scope in 10.2 is reinforced by a provision found in Article 5.3 of the treaty. So that's 142 and 143 of the Core. If I could start with Article 5.1 and 5.2 just to explain what I mean. Your Lordships will see that in both Article 5.1 and 5.2 are something called most favoured nation clauses, which the Court may be familiar with, that essentially allow investors to take advantage of the most favourable obligations offered by the state to their own investors or foreign investors of a third party, whichever is the most favourable. You'll see in the second sentence of 5.1 and in 5.2. So there is a long-running debate in investment law about whether such a clause would permit an investor not only to import a more favourable substantive obligation, so he gets a higher standard of treatment through a different treaty that India has entered with a third state, and he can incorporate that via the MFN provision. That's okay. But it's controversial as to whether the investor can also take advantage of a broader offer to arbitrate in that other treaty. So if you imagine India enters into different BIT with Spain or Egypt, just as a hypothetical example, if that has better substantive protections for an investor, the MFN clause allows that investor to rely on that provision vis-à-vis the substantive protection. Very controversial as to whether he can also say, well, my scope to offer to arbitrate is limited in my actual treaty. Can I borrow a wider arbitration offer from another treaty? And what Article 5.3 does is say no. Provides, as you'll see there, that this article shall not apply to procedural or jurisdictional matters, notwithstanding the provisions of any BIT they may have signed before or after the entry into this treaty. So here, a deliberate choice has been made to provide that the MFN clause cannot be used in that way. So any wider offer to arbitrate made by India in any other BIT cannot be used by Emirati investors to access investor-state jurisdiction. And that only makes sense if the parties to this BIT deliberately intended to limit the scope of the offer to arbitrate and to preserve that limited scope. It reinforces the point that the parties did not intend for the scope of substantive protections to coincide with the scope of investor-state arbitration. So whilst they were content for investor to rely on the MFN clause to borrow substantive rights in other treaties, he could still only bring a claim in respect of that new right under Article 10 if he could point to a qualifying measure, capital M. So just to take stock then at this stage and draw those three threads together, these 3 points, the dislocation of right and remedy, the narrow Article 10.2 and the MFN exclusion are important when considering the scope of the term measure, because they show in our submission that one must be careful not to read this treaty with any assumption that if the instrument provides investors with a substantive right or imposes an obligation on the states, that must have been intended to carry with it a remedy via Article 10 for the foreign investor in order to facilitate the promotion of investments. As I said earlier, that places far too much weight in our submission on the preambular rubric of promotion of investments, and far too little weight on what are bespoke features of this treaty, which indicate that far from the parties wanting to create the widest possible avenue for investor-state arbitration, they quite carefully circumscribed those circumstances in the way I've just identified. My lords, there's nothing unusual about what I'm saying here, although we say the treaty wording here is unusual, but that dislocation, Mr. Wordsworth showed you earlier, EAIB in Slovakia is a good example of that. I won't take your lordships to it because you looked at it, but there was dislocation in that treaty. There was an FET obligation in Article 2. It was accepted that, subject to the MFN clause in that case, no investor-state arbitration in respect of it. The debate in the EAIB case was about the scope of the expropriation provision. It provided on its face that if there was a dispute about the amount of compensation or method of payment, you could take that to investor-state arbitration. The question was, did it also allow you to take the liability question to investor-state arbitration? Answer no, and Mr. Wordsworth took you to the relevant passage, which explained why that was not a concern at paragraph 385. I won't take you back to it, but that is, as I say, an example that the sort of thing that I'm talking about here is not unusual. The fourth point is why does this treaty have these features, and what's the explanation for this? As you'll have seen from para 116 and 117 of the judgment, His Lordship, Mr. Justice Knowles, suggested that there was no explanation for the limited scope of the treaty on the tribunal's analysis, and that is, with respect, not correct. Explanation can be found both in the terms which I've just discussed and in its surrounding circumstances. Just by way of opening context for this point, there was no India-UAE BIT before this treaty, so no investor-state protection before the agreement entered into force, which was in early 2014. And for what it's worth, RAKIA itself had already purchased its entire shareholding long before the BIT came into place, and at a time when there was no treaty protection in place. Just for your note, you can see that in RAKIA's statement of case at tab 20, the supplemental bundle, page 341. It completed all of its purchases of shares in ANRAK by August 2009, the 42 million. Now, this treaty was entered into in specific circumstances and in a particular climate, which helps to explain these features. Mr. Wordsworth has referred briefly to the White Industries decision in late 2011, a decision which was issued by an investment tribunal that held India liable for a failure of its court system to provide an effective means of asserting claims through the use of an MFN clause. The consequence of that decision was fairly seismic in India. It's addressed in the award, my lords, at paragraph 94 and 95, which is in supplemental bundle tab 1, page 28.
You just help me before we get to Which aspects of the Vienna Convention do you rely upon for saying this is relevant?
Sure. So, my lords, a few aspects. So, Article 32 of the Vienna Convention, we just actually. If my lord has the first volume of the authorities bundle, and it's tab 1 at page 6. So, recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion, in order to either confirm the meaning resulting from the application of Article 31 or to determine the meaning when the interpretation according to Article 31 A leaves the meaning ambiguous or obscure, or B leads to a result which is manifestly absurd or unreasonable. So I'd seek to rely on two parts of that, my lord. First of all, the circumstances of its conclusion, which is very wide, and I can take you to some textbooks which explain that. And secondly, we will look at the previous drafts of the treaty, and that is travaux or preparatory work of the treaty. And so we say we can consider that. If it helps, in respect of the prior drafts, one can see from the Supreme Court's judgment in Polska an explanation for this.
But to understand more broadly, are you saying that the meaning is ambiguous or obscure?
No, my lord.
And are you saying that it's manifestly absurd or unreasonable?
I'm not, my lord, but in
all you're relying upon it on, in that case, is to confirm the meaning resulting from the application of Article 31. That's the only basis upon which you are entitled to rely upon it.
Correct. But
so it doesn't help us in the interpretation under Article 31. All it can do is, if we reach a conclusion under Article 31, then we can then rely upon this material to confirm that meaning.
Well, my lord, the Supreme Court has actually held in the Polska decision that the two conditions A or B only apply in the context of requiring a determination of the meaning. So in the Polska decision, it's in authorities bundle. It's in the authorities bundle.
A or B applies to determining.
Correct.
Otherwise, and you're not seeking to do that, what you're seeking to do is to confirm.
Yes.
So, but first of all, we have to reach the decision under Article 31, don't we?
One does, but as I say, looking at the surrounding circumstances has been held in that decision to also inform what the object and purpose is. So in Polska, if I can just show your lordship, this may help. If it doesn't, please tell me. So it's page 844 and 845 of the authorities bundle.
So which volume tab is that in, please?
I'm sorry, just one second.
So it might be in volume 3.
Sorry, it's volume 3, 41. Apologies.
So what paragraph did you say?
So if your lordship start at page 843, so it's paragraph 24 and 25, Lord Hamlin sets out the relevant provisions. Paragraph 26 refers to Article 31, ascertaining the ordinary meaning. and the single combined operation test with which your lordship is familiar. And then Article 32 is picked up at paragraph 28. And then the lordships will see there was an issue in that case as to whether the travaux which was seeking to be relied on disclosed a bullseye. You'll see at paragraph 32. But Mr. Kimball KC for the appellants submitted that this was only required where they were used to determine rather than confirm meaning. I accept that submission. The use of supplementary material to confirm a meaning is not subject to the restrictions set out in 32A and B. They only apply when the material is relied upon to determine the meaning. Moreover, confirmation may consist of finding support for a given meaning. It does not necessitate the identification of a definite legislative intention. It may, for example, include material which helps to identify the object and purpose of the treaty or provisions within the treaty. That will be a useful aid to interpretation, but it is unlikely to disclose a definite legislative intention. And then they go on at 34, His Lordship to explain it's not possible to be categorical about what documents may properly be regarded as comprising preparatory work or travaux, most likely to be part of the formal record of the convention rather than expressions of interest, of opinion or policy. Examples include official explanatory reports, agreed conference minutes, so on, and earlier drafts of the treaty. So I accept that we're not relying upon this material to determine the meaning, but we are seeking, and we're entitled, we submit, to rely upon it as part of the VCLT approach to assist in confirming the meaning, including as...
I must be missing something, because if you have determined the meaning, then what does confirming it add? It sounds a bit like belt and braces. I know the Supreme Court say that's what you can do, so it must be right, but I'm not quite sure what it adds.
I think... Bear with me one second, Roger. So the recourse that's considered in Article 32 to the other material is in order to determine the meaning. So it doesn't assume that you already have determined the meaning. It is that you're looking at that the drafts of the treaty, say, to determine the meaning in the second limb of Article 32. So you can use Article 32 in two ways. The one that your Lordship asked me about was to determine the meaning. So if your approach under Article 31 leaves the meaning ambiguous or obscure, that's your gateway into determining the meaning.
Yes.
So you have to get through the sub A or sub B gateways.
Yes, but you say we're not in that.
Oh yeah, we're not in that.
We're only interested in confirming something we've already decided.
Well, but as part of the argument, my lord, I'm entitled to refer you to the surrounding circumstances in order to confirm the meaning that we say follows under Article 31.
You say that it may support your arguments under 31, and so if a court looking at it isn't quite sure, it can rely on the material in order to confirm, as it were, the preliminary view that it's reached.
Precisely.
And I think in one of the passages you just took us to,
Paragraph 32.
is it 32?
Top letter A.
Yeah, so that's where he says, moreover, confirmation may consist of finding support for a given meaning.
Precisely.
So
Sounds
that's
like determination to me.
well, the problem is that the convention refers to confirmation and determination.
Yeah. I'm sorry if I confused matters, but there are two distinct avenues under 32. And what we are looking at here is the first avenue, which is to confirm the meaning, which, as my Lord Justice Miles said, is one can rely on this material for supportive purposes. And that, we say, is also supported itself by what Lord Hamblin says at paragraph 32 of Polska. We say it confirms the meaning of what we respectfully say Article 31 already demonstrates.
But before we put that away, in looking at whatever it is you're going to take us to, we're at paragraph 35, we're looking at documents which demonstrate the common intention of the parties. So we're not just concerned with what India wanted to achieve, but also with what the UAE wanted to achieve.
My lord, that's correct under the label of preparatory work of the treaty. So when one looks at paragraph 34 of Polska, if your lordship has it in front of you, the court there is looking at what preparatory work or travaux is. So yes, that's absolutely right. But when one's looking at preparatory work, that material, one needs to identify documents that demonstrate the common intention. That's paragraph 35 of Polska. But also, one is entitled to look at a different thing, which is the circumstances of its conclusion. And the circumstances of its conclusion is wider than preparatory work. It isn't limited to what is said in Polska at paragraph 35, where they were specifically looking at the question of what constitutes a travaux. If you would like some assistance with that...
is it going to be your submission then that the circumstances of its conclusion enable us to look at something which shows that it was the intention of only one of the parties to achieve a certain result, and that in effect is successfully achieved regardless of the intention or wishes of the other party?
No, my lord. It's going to be that one can look at the circumstances of the conclusion as an objective question, and I would like to show you material which we say demonstrates what the objective position was at the time. Yep. Just to help you on that point, if I may, there is commentary on the width of circumstances of its conclusion that we have in the bundle, in the authorities bundle, at tab 52, which is in volume 4. It's a discussion by Messrs. Courtine and Klein on the Vienna Convention. And it's tab 52 of volume 4, page 1186 and 1187. So the commentators, if you cycle back a page, you'll see they're discussing Article 32, and here they're discussing specifically the circumstances of the treaty's conclusion, and there's a useful illumination of the width of that.
It's always dangerous to use analogies from domestic law, but it sounds quite like factual matrix, or as Lord Hoffman explained it, all the circumstances known to both the parties. I know I'm not for a minute going to fall into the trap of applying domestic law here, but even that passage in 41 that you've just taken us to talks about the common intention of the parties, and that seems to be, for obvious reasons, the target. It can't be enough that one party felt queasy about new treaties because of the way it's experienced in a previous case, can it?
I mean, it may be helpful, my lord, just to, because we're obviously dealing in the abstract at the moment, and I'm not showing you anything which hasn't, or I'm not proposing to show you anything which isn't in the bundles, and that there's any question of its admissibility. So if I can take you to the material, and then it may help illuminate the debate.
Just before we do this, you've taken us to this commentary. The current edition of Mustel and Boyd seems to have quite a lot about investment arbitration, but I see that neither party has cited it. Is that because everybody is satisfied that it has nothing whatever to say that is going to assist us on this case?
I should ask the author of the chapter who's sitting on my right.
Right, well, we'll assume that is the case, unless we're told otherwise.
But also, I was going to just invite your lordships to have a look at the award, please, at paragraphs 94 and 95. So that's supplemental tab 1 at page 28. And your lordships have probably already considered these paragraphs, so I won't read them out. But there, the tribunal is considering the context in which the treaty was entered, and in light of the white industries arbitration. At paragraph 95, it notes that the consequence, which I don't believe is in dispute, was that the Indian government put its BIT program on hold, set up a committee to advise on the provisions which future BIT should contain, so on. And the tribunal noted towards the end of 95, would not be unreasonable to consider the UAE treaty reflects an ad hoc attempt by the Indian negotiators to provide protection acceptable to the UAE, but to remedy what they regarded as defects in the terms of earlier treaties. For example, the exclusion from Article 10.2 of claims based on the acts or failure to act of the judiciary looks like a reaction to the white industries case. To show you, if I may, RAKIA's evidence placed before the judge about this. So it's in the same bundle at tab 4 at page 175. So this is Ms. Bradfield, then the solicitor for Ras Al Khaimah Investment Authority. Page 175 of the bundle. You'll see that Ms. Bradfield's dealing with events post-white industries. Paragraph 28, she refers to Langley 1. Mr. Langley is my solicitor. Refers to the tribunal's view. And then she says, I detail the events that followed white industries below. Up until 2011, BITs had not received significant attention in the Indian Parliament or in Indian media. In November 2011, India lost an award to white industries. Thereafter, India received a notice of arbitration from Sistema in relation to the cancellation of telecommunications licenses by the Supreme Court, and a number of disputes and arbitration notices followed. This was debated in the upper house in March, and then the Minister of Finance, March 2013, you'll see there stated that in view of the recent developments, including an adverse arbitration award, case of white industries, various other dispute arbitration notices served on the government by foreign investors, the government has decided to put all investor-state negotiations on hold. On the 6th of May, it was announced India would review the model BIT. No other BITs were signed between 2012 and 2017, other than with the UAE. And there's an ICSID review article from this time, published in the spring of 2014, which sheds some further light on this. It's volume 4 of the authorities at tab 57. Headed India and bilateral investment treaties, a changing landscape. So volume 4, tab 57. And just to pick up on a couple of relevant parts of this. So at page 1332, it's obviously a long paper, but it refers there to the White Industries Award against India. The case originated from White Industries challenging the inordinate delay by Indian courts to enforce an international commercial award the White had obtained against an Indian company, Coal India. The tribunal held India guilty of not providing White Industries with an effective means of asserting claims and enforcing rights, despite the fact that the India-Australia BIT does not mention or include such a duty. The tribunal got around that by holding that White Industries could borrow the effective means provision present in the India-Kuwait BIT by relying on the MFN provision. Over the page, sort of near the first hole punch, it's important to mention that this case, for the first time, confirmed the broad meaning of provisions such as MFN, was an eye-opener for Indian BIT policymakers. Towards the bottom of that page, you'll see the authors referring to a plethora of notices issued against India. Refers to the Systemic case regarding the cancellation of telecoms licenses by the Indian Supreme Court. The same year also saw another global telecom giant, Vodafone, serving a notice to the Indian government after India had introduced, over the page, amendments to Indian tax laws overruling the Supreme Court judgment in favour of Vodafone, and so on. And then at 1335, the author again refers to the heightened focus on BIT's change. Again, as you'll see in the sideline passages, I won't take you through it all, but at the end at 1337, India decided to put on hold all its ongoing BIT negotiations and to review its BITs in light of that. Now, my lords, that was, we say, the position at the time, and we have minutes in the bundle of the rounds of negotiation which the parties held over the treaty, in which they exchanged drafts. And I say we are entitled to look at those where they disclose a common intention, or insofar as they help to identify the object purpose of the treaty or surrounding circumstances. If I could ask your lordships please to go to the supplemental bundle, tab 30. That's at page 425. Now, these are...
Sorry, 425.
My lord, it's 425 in the supplemental at tab 30. Hopefully you've got...
That doesn't correspond for me because tab 30 begins at 435. But you want agreed minutes of the third round, do you?
I do, my lord.
Okay, well that is 425.
Thank you. I'll go by the paragraph numbering. Apologies.
Thank you.
By the pagination. So agreed minutes of the third round of negotiations held in New Delhi on the 15th of March 2007. So the delegations met in March 2007 to consider the outstanding issues. Then in the second paragraph is the key. While agreement was reached on most of the outstanding issues, the issue relating to exclusion of investment in hydrocarbon natural resources, the exception of procedural and judicial matters from MFN treatment, and the procedure of settlement of disputes between a contracting party and an investor remained outstanding. These issues have been kept in square brackets. And what you'll see, Lords, if you click through this, page 427, is the beginning of the draft of the treaty that was being discussed here. And if one moves, please, from 427, just flick through, you'll see investments defined, 428, it goes to 429. you'll see there's no equivalent to what we have in the final agreed version of measure, which occupies Article 1.8. And the scope provision is different. So there's no concept of measure at this stage. It's introduced. No carve out for tax in Article 2 either. And then the dispute resolution provision at Article 10, which one can find at page 436 onwards. There's two versions of it. They obviously hadn't agreed because it's in square brackets, and that's reflected in the agreed minutes. Is a very wide formulation in both iterations. And again, no capital M measure concept introduced at this stage. So 10.1, disputes arising between a party and an investor in respect to an investment. And the alternative formulation is very similar. So it's what one might call a conventional wide investor state offer to arbitrators being debated. The differences between the two formulations here are about which body might administer the arbitration and so on. So that was the position back in 2007 in the third round of negotiations. Could I please ask you to turn to the next tab, which should be at page 443. And these are, my lord, I hope I've taken you to the right place, but it's agreed minutes of the 3rd and 4th of July 2013. Appreciate it. And the second paragraph is important. So they met in July 2013. The India side expressed their concern about various provisions enshrined in the text, which was being discussed in 2007. That's what we just looked at. And requested for a relook at various provisions in view of the evolving international legal jurisprudence in the field. This is July 2013. The White Industries case was towards the end of 2011, and all the notices that we were looking at were around that time too. The UAE side explained that the purpose of the visit is to have discussions limited only to the 3 outstanding issues identified during the 2007 discussions. That was the hydrocarbons point, MFN and dispute resolution. At the end of the discussion, it was agreed the Indian side will send a revised text which will capture their concerns related to various provisions under the agreement. The UAE requested the revised text be based on the previous text and references be made to other agreements signed with other countries with the proposed modifications. And then what one sees as the final round of negotiations at page 446, the 5th round. This is 3 or 4 months later, October 2013. You'll see from the middle paragraph, third paragraph, sorry, the negotiations were held in a friendly and cordial atmosphere. The two delegations agreed upon the text of the agreement ad referendum as enclosed, Annex 1. And then they communicate for signature through diplomatic channels and so on. So what follows is the agreed text. So July 2013, they got back together to discuss on the basis of the 2007 document. India had expressed its concerns, and then in October it identified an agreement. And it's at this juncture, as you'll see, in other words, from page 450, that it introduces capital M measure into the agreed text, and that carries through in the way that we've seen in the executed BIT, including in a revised Article 10, which incorporates that in concept in 10.2, 10.3 and 10.8. My Lords will also see that it now excludes matters relating to taxation, for example, in Article 2.3.
And is what we're seeing here identical to the final version?
My Lords, it is save that in the very final, if one goes to 465, it's not been executed, so there is a difference just in terms of...
Yes, the text is the same.
Yeah. So what one sees, my lord, is that there's a concern expressed in July 2013 from India, evolving legal jurisprudence, and a concern which we say is evident through the other material and in the agreed minutes. And the approach then taken in the agreed text is through the concept or introduction of the concept of capital M measure, including into Article 10.
What do we draw from that?
My lord, what we can draw from that is that the introduction of measure, circumstances surrounding the agreement to this treaty inform how measure was to be treated. They confirm what we say it was seeking to do.
How?
Okay.
I don't follow how it does that.
Okay. Well, it does that because at the time of the agreement to this treaty, at the time they were considering this point, we say objectively, it's clear that there were concerns on the Indian side as to the evolving, as they called it, the evolving international jurisprudence. Point one. Point two is what one sees then in the agreed text is the introduction of measure into the agreed text. We say that the combination of those things supports our case that what measure is seeking to do, and one reads the actual final agreed text, and you put it all together, is to restrict the scope of the offer in terms of investor-state arbitration, and to address those concerns that have been articulated in that material.
Well, how do we know that? Because we know the UAE agreed to it, but they may have agreed to it because they thought it had the meaning that they're now arguing for.
What we actually see is that India say, we want to have a look at various provisions because there have been developments in the field. They don't specify this is all about white industries, although maybe that was to be read between the lines. UAE say, no, we don't want to go over it all again. We got this far, let's just stick with the bits that are outstanding. In India go away and produce something, and then we get the final version. So, it seems to be a bit of a leap to draw from it the conclusions that you seek to draw. Possibly you might say that because the problem, the white industries problem, has been to do with delay in the Indian courts, that taking judicial decisions, or perhaps the absence of judicial decisions, out of the definition of measure and the offer to arbitrate might have something to do with it. But does it help us on the meaning of applied directly?
My lords, what it helps you on is on how measure was introduced into the instrument. I accept that I'm not seeking to take it much further than that, because it's a late introduction into the agreed document and reflecting, as we say, the concern relating to white industries and the carve-out of judicial responsibility. In terms of what the meaning of applied directly to is, we do say it does give you some assistance because it's built into the concept of measure, which is itself part of the offer to arbitrate, or delimits, we say, the scope of the offer to arbitrate, so that one can look at this material and understand what measure was seeking to do. But I don't want to, as it were, I want to get on to what applied directly to means in the context or in the situations that have been put this morning. So I don't want to belabor this point unduly, and I'll move on to the shareholder protection concerns that the court.
Certainly, in some travaux, you will see parties, particularly in multilateral treaties, where the parties are actually discussing amongst themselves what the provisions mean, and different parties will say what they understand them to mean, or what they want them to, and what they will and will not agree to. And you can perhaps get from that some sense of what the parties to the treaty actually meant by these words. Although even then, in my view, very often it doesn't help as much as people might suggest. But here, there's no discussion between the parties to the treaty of what the actual words included are intended to mean.
No, my lord, I wasn't. If I dangled that carrot in front of the court, then I apologise, because that wasn't what I was intending to suggest the material was going to. It is, at best, confirmatory of what we say on an Article 31 construction. The approach is you don't have agreed travaux that reflect that position. I accept that. But it is helpful, we say, for the reasons the tribunal indicated, in giving a sense of what the surrounding circumstances were, as my Lord Justice Mayles identified, the exclusion of judicial responsibility.
Well, you'd accept it. If one, looking at the terms of the treaty, did not think that it had the effect for which you contend, this couldn't help in any way, could it? I mean, in a sense, you interpret the provisions, and either that, and the result you come from the interpretation, well, either it means what you say it means, and then you can say, well, that's how it came about. But if it doesn't so mean, I don't see how the fact that you can show these documents help.
Well, I think rather than try and debate that on this material, I would like to go then to the text of the treaty.
I have to say, I do think that in these treaty cases, one can be taken to huge amounts of travaux and other material, and at the end of the day, it adds almost nothing to the wording of the treaty.
Well,
and I think maybe this is one of those cases.
My Lord, let's consider that then. I was wrapping up on the structural points anyway, and you'll recall I mentioned the judge's observation that on the tribunal's analysis, shareholdings would, he said, fall outside the compass of the BIT. It's not quite an accurate or fair characterisation of the result on India's case. As we've recognised, RAKIA shareholding is a capital I investment, so substantive obligations applied to it. That means that shareholders do get access to investor treaty arbitration where executive action is applied directly to that shareholding investment, whether that's expropriation of shares by executive order, interference with voting rights, for example, interference with the right to an accrued dividend. So there are measures of protection, but again, we respectfully say the court should not be concerned that there isn't further protection. That would be to start from entirely the wrong premise of what this treaty is designed to achieve. And again, I hark back, one takes the legislative decree example. In this treaty, the parties accepted that India could just take RAKIA shares through a legislative order that would be an expropriation. It would be a measure applied directly to RAKIA shares. It would not give investor-state arbitration under 10.2. That's the framework or prism through which we would invite your lordships to consider matters. Now,
what that does mean, as I understand it, is that introducing the term measure isn't a way of delineating jurisdiction.
It is, my lord. It's part of the way of delineating jurisdiction because it's in 10.2. But then jurisdiction in 10.2 is further narrowed by reference to the executive measure.
Well, if you can have measures that aren't within, if you have measures that aren't within the arbitration clause, then it doesn't delineate jurisdiction, does it?
Well, one needs, in order, apologies if I haven't quite followed the question, but one needs to have two things in order to accept the offer to arbitrate. One needs a capital M measure, that is a form of binding action applied directly to the investment, first point, and then that needs to be an executive measure, an executive action. If one could have a legislative measure,
I think the point is that you can have the concept of measures isn't introduced solely to determine jurisdiction.
No, that's
Because, as you say, you can have measures
yes,
which don't result in the right to arbitrate.
yes.
And I think that's not the only way in which measures is used, is it? Which don't give up. What about Article 7?
Yes.
On your case.
Yeah. Okay. My lord, I can come to Article 7. I will come to Article 7, if I may, shortly.
Just looking at the combination of Article 1.8, the definition of measure, and Article 10.2, the offer to arbitrate, with its limitation to executive powers. Well, measure is limited to action under any law, rule, or regulation. So if you have the executive doing something extra legal, an arbitrary seizure of whatever it is, they simply send in the army without any colour of law, then that's not a measure. It is executive action, but it's not under Article 10.2. I mean, doesn't all that illustrate that you can take these points to a degree of absurdity?
Well, one can take points both ways, as it were, my lord, to a degree of absurdity. We're not suggesting that our construction does result in any absurdity, obviously. Can we look perhaps at how measure is deployed through the agreement, because that might help then shed light on this. So if I can just begin perhaps with, we've looked at the ordinary meaning points. I don't need to trouble you with those. If I can just pick up on a couple of points of context in relation to how Mr. Justice Knowles approached the construction of measure, and as it were, clear the decks on that before coming to the other provisions that you've pointed me to. Now, what Mr. Justice Knowles did, essentially, when construing what applied directly to an investment meant, was he considered it meant targeted at investment. One can see that at paragraph 112 of the judgment, where he sets out his agreement with the position that RAKIA was then articulating. He said that the action taken was not an action directed elsewhere, but having adverse collateral effects here. Pausing there, that is one of the arguments they now make on the respondent's notice. RAKIA's argument puts things in this way, and correctly in my view: measures are applied directly to an investment where they are targeted at the investment. The position may be different with measures of wider general application that may or do have an adverse effect on the investment in hand, but on assets invested elsewhere too. So, his lordship envisaged the test of applied directly to, correctly interpreted as a test of action targeted at the investment. Now, my lords, we say that's wrong on the proper interpretation of Article 1.8. Just a few short points on that. First of all, applied directly to an investment on its ordinary meaning is not binding action targeted at the investment. The parties could have said that action targeted or directed at an investment was sufficient, but they did not. We say they actually went for a more precise requirement, namely that the action be applied directly to the investment. If binding action is targeted at an investment, it may or may not be applied directly to it. That will depend on whether the binding action reaches its target. The problem with the judge respects substituting the wording actually used by the parties for the wording targeted at is that that wording does not require direct application of the binding action to the investment. The second problem is that there is nothing in the wording of the definition to support Mr. Justice Knowles' rationale that a measure was intended to distinguish between binding action applied to a particular project and wider action. One cannot get that out of the ordinary meaning of the words applied directly to. Those words certainly don't require that the action only be applied to the investment in question. And if the parties had wanted to distinguish between action targeted at a particular investment and wider state action that applied to many different investments, they would have used that wording. And the court will note that there's no real explanation given in the judgment as to how one can move from applied directly to targeted at, nor is there in RAKIA's skeleton. And the contrast made by the judge between a targeted measure and one of wider application is difficult to follow when considering the definition as a whole. You'll recall that the definition refers to any form of binding action, which is very wide. Clearly, one could easily think, as a matter of ordinary language, of a widely applicable regulation that applied directly to an investment. Take, for example, an Indian emissions regulation that applies to every refinery or factory in India of a particular type. That would, as a matter of the ordinary meaning of 1.8, be a form of binding action, tick, applied directly to each of those factories, tick. If title to the factory is held by a UAE investor, in that example, it would be a measure. And there's no sensible reason why, on the ordinary meaning of the term, that cannot be considered a form of binding action, and thus a measure. And regulation often takes place on a sectoral or general basis rather than on an individual project basis. And at the time of the treaty, it's fair to say that Emirati and Indian investors would probably be just as likely to be concerned about widely applicable regulations that were being applied directly to assets they had invested, as they would about regulations that were being applied only to them as investors. Fourth, on the facts, if the investment is only the shares, how can it be said that GOM 44 was targeted at that investment? We do not accept RAKIA's case. The judge was saying that GOM 44 was targeted at the shares. We submit that at para 111, he was saying it was targeted at the BSA.
Your previous example, the emissions regulations, would qualify as a measure, but you say would not be within the offer to arbitrate.
It would depend, my lord, on what the nature of the measure, what the nature of the regulation was. So if it was a executive action, as it were, I appreciate that a regulation would usually not be considered within that, but yes. So it would depend upon the precise nature of what the form of binding action was. But if it was a law that was passed governing emissions for environmental reasons or what have you, then yes, it wouldn't be.
What about secondary legislation in our system? I don't know whether India has the same, but if the executive lays regulations before the legislature, then sometimes you need a positive resolution, sometimes you don't. It just takes effect unless there is a negative resolution. Would that be within Executive Act or not?
Well, I'm not seeking to dodge that question, but it's difficult to say.
It's not the facts of our case.
It's difficult to say in the abstract, and I'm not an Indian constitutional lawyer, so I appreciate the example that your lordship's giving to me. I'm slightly hesitant to try to set out what the position would be because it would depend, as a matter of Indian law, I think, how that's considered within its system.
Okay.
One of the problems with interpreting this is really the drafting, to make a very obvious point, but it says that the measure is binding action under any law, rule or regulation which applies directly. And if it's a rule or regulation or law, the idea of applying to an investment is not very hard to understand because you look at the rule and see whether it applies to the investment. it seems to me it's not quite so easy to do that in the case of an executive, what's actually here, an executive direction to APMDC, it seems to me, if it's anything. But it's not really clear that that's a rule or regulation or law. I mean, the judge dealt with this very briefly, and I'm not suggesting this is an answer because no one has taken this point, but it makes it very difficult to interpret, I think.
Yes, my lord. And there was a debate in front of the tribunal on the sort of issue that you've raised in terms of how one moves from GOM 44, which was directed at APMDC, to take a particular action, and that carries through into the action that was then taken vis-a-vis the BSA. There was a debate on attribution and so on, and whether this was in fact a binding a law, rule, or regulation and binding action. The tribunal assumed it without being, I think, persuaded that it was necessarily so. And as your lordship identifies, Mr. Justice Knowles deals with the point very briefly. It's not challenged on this appeal. I'm not sure I can help your lordship much further with that at this juncture, but what isn't controversial between the parties is that however Mr. Justice Knowles got there, we have accepted for the purposes of the appeal that GOM 44 was a binding action taken by the contracting party, applied directly to the BSA. And that's what his lordship finds, paragraph 100. The question really then is how that fits within, if it does, Article 1.8 and to RAKIA's investment. And on that point, there's no explanation in the judgment as to how that application to the BSA translated into direct application to the shares. There's no finding that it was targeted at RAKIA, or targeted at the shares that RAKIA held in ANRAK, or targeted at the shares or shareholders in ANRAK at all, let alone that it applied to them. And it becomes even harder to see how the test was met, given that his lordship specifically rejected a measure as being one which is targeted at one investment and has an adverse effect on another. So the position on the facts seems to be that if the measure was targeted at a particular project or industry in the state, that was sufficient under 1.8, even if not applied directly to RAKIA's actual investment as Mr. Justice Knowles found that investment to be. And with respect, we say that is obviously an incorrect approach on the clear definition of measure, which requires a capital I investment, as Mr. Wordsworth has explained. And one can't get there through the term applied directly to. On the judge's approach, the action has to be targeted at the project, but not actually applied to the investment itself. It's sufficient if the action is targeted at the project in which the investment sits, but not to the asset invested by the investor in India. And we submit that can't be justified on the ordinary meaning of Article 1.8.
Can I just understand this a bit better? Measure isn't the law, rule, or regulation, is it?
No, it's a form.
Measure is the action,
Right.
the binding action. And so when you come to 10.2, it covers a measure that is a binding action, which is an exercise of executive powers. So it's saying nothing about the source of the power, whether it's a law, rule, or regulation. So if an Indian government, central or state, exercises executive power which is under a law, rule or regulation, that is arbitrable. There's no requirement, it seems to me, that it's a purely executive derived power. It only has to be executive action. So if, for example, there was legislation passed saying you shall not do something, then the executive action in enforcing that would be within 10.2. Would it not?
If the executive action was applied directly to the investment.
Yes. So I'm not slightly doubting this distinction between legislation and something else. I mean, the executive powers may be granted by legislation. Anyway.
Of course, my lord. I mean, the executive will usually have powers to act as a result of legislation. That's not surprising as a proposition.
Yes.
The surprising feature of Article 10.2, in the context, well, not surprising in the context of this treaty, but the important features of it are that it will not apply to the legislative action itself. So if there is a measure, capital M, which is the product of legislative action, that will not be captured. Equally, if the judiciary make an order which constitutes a measure, that will not be.
Well, I can see it would exclude a judicial order, which may well be what was sought to be achieved. But I can't see that it would exclude a legislative measure, which is then enforced by the executive.
Well, it rather depends, my lord, on what we mean by legislative measure and what the legislation is doing.
Well, is there any legislative measure which would be enforced other than by the executive?
What I mean by that, my lord, is it depends on the nature of the... In the example that you're putting to me, one can think of many situations where there is a legislative decree, let's say, unpopular investment in a particular state, and they say, we don't like this investment, we want to take it away, and that action is taken purely by legislative decree. So there's an order. That wouldn't count under 10.2.
No. But when the government comes to enforce that through the exercise of its executive power, that would be a measure. So when it comes along and says, we now have the order to dispossess you or to enforce or whatever, that would be executive action.
Well, in the example your lordship's giving me, yes, if it's a legislative action which gives the executive power to take executive action, the executive then deploys the measure, capital M, then I have to agree with what the
so
point
the only thing it does effectively is excludes judicial.
No, my lord. It also excludes, as well, let's take primary legislation as an example of, as I say, if Parliament simply issued a decree that said, as a matter of Indian law, this property is no longer RAKIA's. That would be excluded. One couldn't challenge that.
No.
Yeah. So
but so somebody came to enforce it against you, you could.
Depending on what the legislation.
Well, how would any legislation be matter to you unless it's enforced against you?
My lord, again, with apologies, the facts become quite important in the examples you're putting to me. So, for example, if the enforcement in this example ended up in a judicial order, for example,
yes,
that's not covered. So there would be, I accept on your example that there is a scenario where legislation gives power to the executive to take a measure, and that would be covered by this. But in our submission, it doesn't detract from the pretty radical force of what this treaty is not providing for. I mean, there are obviously examples which your lordship has put to me of situations which would be covered by 10.2. Fine, we accept that within the scope, as your lordship has put to me. that doesn't detract from the key point. We say judicial acts or omissions not included. If I can put pure legislative acts, if I can just use that description for convenience, not included. Of course, delegated powers to an executive pursuant to legislation, which they then use to adopt measures against an asset. Okay, yes, that's covered by 10.2. Now, what is clear, though, my lord, despite those examples, is we say that one can't get there on the targeted at approach to RAKIA's shareholding, as the judge found. Just a couple of points of context, because just to address Mr. Justice Knowles' distinction between targeted action and wider, generally applicable action, we respectfully submit it can't survive a couple of contextual points. One is Article 14.2, which you'll have seen that we address in our skeleton, which provides that nothing in this agreement precludes the host state from taking necessary reasonable measures in accordance with its laws applied generally on a non-discriminatory basis in circumstances of extreme emergency for the specific purposes of prevention of diseases or pests. This is an important provision, we say, but one which the judge placed insufficient weight on with respect, because it's difficult to see how one can reconcile that provision, which anticipates wide-ranging measures being taken by the state, with the judge's analysis of a measure that required the targeting at an investment, contrasting that targeting with measures of wider general application. The only reason...
That's really a merits defence, isn't it? And that's to say there could be a measure taken for health reasons,
correct,
about which there was complaint, and it could satisfy Article 1.8 and 10.2, but then India would, so the tribunal would have jurisdiction, but then India would say, well, that was a necessary reasonable measure for these purposes, and the arbitrators would have to decide whether it was.
Absolutely, my lord. This 14.2 provides a merits defence, as you say, but the important point is it contemplates measures which are generally applicable or applied generally on a non-discriminatory basis. So the problem, on Mr. Justice Knowles' analysis, measure meant targeting at a particular project. And this clause envisages statewide, nationwide, region-wide measures applied generally on a non-discriminatory basis.
It does, though, does it? Because, again, measures is action.
Yeah.
So what it's saying is nothing prevents the contracting party from taking reasonable action in accordance with its laws applied generally on a non-discriminatory basis.
But my lord, we would say that the application, its laws are being applied generally. The applied generally is referring back to the measure, that's just the action that's been taken. That's how one would make sense of that provision.
No, I think what it means, doesn't it, is that if the action in this case is in accordance with its laws, which measures have to be under laws, which are applied generally and non-discriminatory in circumstances of extreme emergency.
So our reading of that, my lord, is that in order to access this exception to liability, the state needs to be applying the measure generally on a non-discriminatory basis. That's condition 1. Condition 2 is in circumstances of extreme emergency, etc. And what we take from this is that first condition demonstrates that the parties were thinking that you could have a measure that's applied generally on a non-discriminatory basis. Measure being action applied directly to investments. So it's a pointer, and an important pointer, to the parties thinking that measures didn't have to be targeted at investment. And we say you get the same from Article 7.4, and I will be coming to Article 7, in terms of regulatory measures. Now, my lords,
Are you going to address 2.1?
yes, my lord, I will. So there are a number of reasons of context why I'm going to move away from the judgment, if I may, and look at what RAKIA now says. And what RAKIA now says is essentially that Article 1.8 requires direct nexus or an impact on value. It means the same thing, according to it. We say that's wrong as a matter of the ordinary meaning of 1.8, which I think is the point you have. And even on its wording, point I made earlier, it can't show how there was a direct nexus between GOM 44 and the shares, because when one drills down into how they say that's satisfied, they either expand the notion of investment or they have to rely on this test of does it impact the value of the shares themselves. And on that point, my lords, one simply can't get that out of the ordinary meaning of Article 1.8. Does not provide binding state action which directly affects the value of the investment as a measure. Now, just picking up on my Lord Justice Phillips's nudge to me on the context of the treaty, the treaty doesn't support RAKIA's case on this for two reasons. First, because it distinguishes between the application of binding action to an investment and between the effect of that investment on the value of the asset. So that shows that if the parties had intended for the test of a measure itself to turn on effect on value, they would have identified that in the definition. And the second reason is that the ways in which measure is deployed and used suggest it was important to have certainty regarding whether a measure had occurred. Can I start? I will come, my lord, to Article 2, but just can I start, please, with Article 7.4, which is at core 14, page 145. And I could invite your lordship just to read that, please. My lords, we say we get two important contextual points from 7.4. The first is that this is the one example in the treaty of the parties indicating the type of binding action which they had in mind as constituting a measure. This article provides that the term expropriation shall also apply to interventions or regulatory measures, and then importantly gives us specific examples of such measures. It says such as freezing of the investment, blocking of the investment, compulsory sale of all or part of the investment. Each of those or other comparable measures are examples of binding action being applied directly to a specific asset. For example, if one considers a binding action which leads to the compulsory sale of an investment, one is naturally going to be focused on the specific asset invested by the investor that has been sold or is subject to the compulsory sale order. The second thing we get from Article 7.4 is it's notable because here the parties distinguish between the nature of the action that is a measure and its effect on the value of the investment. You'll notice that the first part of Article 7.4, which is sort of until the fourth line just before that have a de facto, that first part addresses the type of measures that the parties had in mind. Freezing, blocking, compulsory sale. The second part addresses those capital M measures which then qualify for expropriation, i.e. that have a de facto confiscatory expropriatory effect, and that their effect results in totally or near totally depriving the investor from ownership, control, substantial benefits, and so on. So this is a clear example, we say, of two things. First, the parties looking at the effects of a measure separately to whether there is a measure in the first place. And second, that where the parties wanted to address the effects of a measure on an investor's investment, they said so. And of course, in that context, in relation to RAKIA's Respondent's Notice case, we submit that if the parties had wanted to make the test of whether there was a measure at all turn on the effect the binding action had on the investment, they would have used the same term, effect, E-F-F-E-C-T, which they've used here in 7.4. My lords, the same point I would make, I won't belabor it, but you can glean from Article 10.8b at page 150. There's a distinction built into that provision between knowledge of the measure itself, capital M, and knowledge that the measure has caused substantial loss or damage to the investment. Parties separated out those two concepts. So that's the first sort of overarching contextual point. Measure does not mean impact on value. C 7.4, C 10.8. The second point is related to certainty. And here we will look at Article 2. Article 2.1 and 2.2, and also we say the arbitral provision, but 2.1 and 2.2 in particular, are provisions which indicate that the parties likely wanted certainty as to whether a measure was or was not being applied to an investment, and which we submit make it unlikely that in deciding on a measure, they wanted to have to consider whether the binding action in question had impacted the foreign investors' investment. So Article 2.1, as you'll see there, my lords, at page 140, the agreement shall apply to all investments made by investors of one contracting party in the territory of the other, whether made before or after the coming into force of this agreement, shall not apply to any dispute arising out of any measure applied to an investment before the entry into force of the agreement. So, if the scope of application of a treaty, at least regarding disputes, this depends on when a measure was applied to an investment, then it was important to the parties to have certainty as to whether a measure had occurred. Investors would want to know whether the investment was in or out of the scope of the treaty in respect of action taken by the state towards it, and the contracting parties themselves would want to know whether the action that they had taken, as at the date of the treaty's entry into force, fell within its scope or not. If the question is, has India taken binding action applied directly to this asset invested by an Emirati investor, that is a relatively straightforward question. If the question is, on the other hand, the one posed by RAKIA, namely, is there a direct nexus between the state's binding action and that asset, or an impact on value, it becomes much more complicated. The same point applies in respect of Article 2.2. It envisages the state obtaining prior consent to the application of binding action directly to an investment from the person who made that investment, i.e. the investor. Or if the investor is a foreign shell or SPV, for example, from the entity owning or controlling it. This is therefore a provision for the benefit of the state. It suggests that the parties wanted certainty about the scope of a measure because it needs to be possible for them to identify with predictability the investor that is about to be the subject of binding action and who can give their consent to it. A measure defined under 1.8, which was applied with the consent of the investor, will be outside the scope of this agreement. Now that's most likely to be the owner of the asset under the applicable law. And therefore, when one considers in this context how the parties likely wanted the applied directly test to work, it's likely they wanted to draw that net narrowly to the specific asset which was going to be the subject of the binding action, so that they could then get consent from the foreign party that owned that asset to the proposed binding action. If the net of measure is drawn more widely, so the test is, for example, whether there's a direct nexus, immediate nexus, impact on value, as RAKIA suggests, then this provision also becomes much more difficult for the state to apply. And so we say that also is a strong contextual point in favour of our narrower reading of measure. And the third contextual point is in relation to Article 10.2 itself. And the short point there, my lords, is that if my learned friend is correct, and applied directly to means impacts the value of the shares, that suggests, or impacts it with sufficient directness, is how I think they put it. That does then make the question of whether there is jurisdiction highly uncertain and unpredictable. But we submit it's unlikely the parties intended that to be the question, whether the action of the state taken against asset A is or is not the cause of loss to the owner of asset B, as the question on which jurisdiction depended. It's entirely unclear, for example, on RAKIA's case, whether there is a particular threshold for loss that would be required to be established in order to qualify as a measure. And what RAKIA's test would do, if it's correct, impact on value, is to convert contested questions of causation, mitigation, and quantification into jurisdictional issues under the treaty. So, for example, one of the issues in the arbitration was whether ANRAK, the local company, was in a financial position to perform the BSA. If it never was in a position to perform the BSA, then it didn't suffer any loss as a result of the state's termination of it, such that the termination would then had no effect on the value of the shares that RAKIA held in ANRAK. And if that argument is proven to be correct in the arbitration, then on RAKIA's case, there would presumably have been no measure applied directly to its investment, and thus the tribunal would have had no jurisdiction to determine the claim. And we say that's an unlikely result as a matter of the objective reading of the terms. So for those reasons, we do say, my lords, that the context of this treaty supports our narrower approach to measure. Now, can I finish with your indulgence with Article 7.3? So in our submission, we say those contextual points show that RAKIA's new case is incorrect. 7.3 is a key provision that my learned friends rely upon, and it's at page 145. And it grants a shareholder a freestanding entitlement to compensation in circumstances where the assets of a local subsidiary have been expropriated. But it does not assist RAKIA as context for Article 1.8 for a number of reasons. Just before I consider those, please note that it has to put tremendous weight on a single provision in the treaty, in the teeth of what we say is ordinary meaning of Article 1.8, all the contextual points we've considered, and the particular object and purpose of this very particular treaty. So we say it is highly ambitious to point to this provision as providing the answer to the proper construction of a definitional section in 1.8. And I make 3 points in relation to that. First, it's important to remember what RAKIA is seeking to use Article 7.3 for. It is seeking to deploy it as relevant context to what the parties meant in 1.8. But Article 7.3 does not use the term measure, nor does it purport on its terms to identify the situation that it is addressing as a measure. We say that's not a promising start, especially when you compare it to the approach adopted by the parties in 7.4 immediately below, where the parties wanted to make clear that a particular binding action was a measure. They spelt that out in 7.4. The parties could have, but did not, adopt a similar approach to the Article 7.3 situation. That is to say, something like, Article 7.1 shall also apply to a measure such as the expropriation of the assets of a local company, etc. So if the court is asking, what did the parties consider to be a measure, the obvious contextual pointer in 7 is provided by 7.4, not by 7.3. 7.4 is the term which expressly uses the term measures, which expressly identifies examples of the type of binding action that constitute measures, and which demonstrates that the parties had in mind binding action applied to the specific asset invested by the foreign investor, such as freezing, blocking, compulsory sale of that asset.
Well, Article 7.3 doesn't use the term measure, but it does use the term expropriates, which has been defined in Article 7.1 in a way which includes direct or indirect measures.
By laws it does, but actually that leads me on to the second point about Article 7.3, which is that actually when one looks at it closely, it suggests the parties did not think that the expropriation of the assets of a local subsidiary was a binding action applied directly to the shares, i.e. that the shareholder had suffered a measure. So, can I just explain that, apropos your Lordship's question? 7.1 applies to measures, capital M. That's clear. You can see that from the text of 7.1 and also from 7.4. In Article 7.3, the foreign shareholder's investment with a capital I is clearly the shares and only the shares and not the assets of the local company. The clause draws a distinction between the assets of a company, the local company, and the investor's capital I investment in the shares. You'll see that throughout the clause. So, investors of the other contracting party own shares. They shall ensure the provisions of Clause 1 are applied to the extent necessary to ensure fair and equitable compensation in respect of their capital I investment to such investors who are owners of such rights or interests. The owners of such rights or interests echoes the wording 3 or 4 lines from the top. The investors own shares, stocks, debentures, or other rights of interest. So, Clause 7.3 contemplates that the investment of the shareholder is the shares. That the assets are not the investment. That's the first point you get from it. Then the question is, if the expropriation of the assets of the local company was a binding action applied directly to the shares, Article 7.3 would not have been necessary. Because, as I've just said, 7.1 applies to a measure. So if 7.1 covers the field of measures, which it does, if the 7.3 situation was thought by the parties to be a measure, it wouldn't be necessary to have 7.3 at all. It would already be captured by Article 7.1. Article 7.1 would have already responded in that scenario. Most likely because the binding action would have been considered applied to the investment. But as we say, 7.3 distinguishes between those. Now, if one looks at the text of Article 7.3 itself, it doesn't help.
It's really a sort of redundancy argument.
It is, Madam. But if one looks at the text of Article 7.3 itself, it also doesn't help RAKIA. What Article 7.3 requires is that the provisions of 7.1 are applied to the extent necessary to ensure fair and equitable compensation. The ordinary meaning of those words is to refer you back to the requirements in 7.1, outlining how one identifies what fair and equitable compensation is. Namely, you'll see in 7.1 it refers to expeditious compensation, 3 lines from the bottom. In 7.1b, it then sets out what compensation shall be, amount to the actual value of the investment based on fair market value, prevailing commercial rate for compensation, etc. And then at 7.1c, if the above mentioned fair market value cannot be readily ascertained, the compensation shall be determined on equitable principles, taking into account all relevant factors, etc. So when 7.3 says that the provisions of Clause 1 are applied to the extent necessary to ensure fair and equitable compensation, that is what it's really referring to. It's referring to the mechanism for how you calculate that compensation. Fair market value or just equitable principles. It does not by its terms require the expropriation of the local company's assets to be treated as a measure at all. And it doesn't mean that a measure can necessarily exist in relation to the shares. Now,
Well, what it seems to say, if I got this wrong, is that when you expropriate the assets, there needs to be compensation in respect of the investment in the same way as in clause 1, and that takes you back to the actual value of the expropriated investment, which seems to suggest that it's eliding the two concepts of the assets of the business and the investment, which will typically consist of the shares themselves.
Actually, my lord, we would suggest to the contrary. It's recognising that the two concepts are different. That if you expropriate the assets of the local company, those are the assets of the local company and not the investment. So they can't be, the expropriation of the assets of the local company cannot be a measure applied to the shareholder.
This is all belt and braces, isn't it? You have 3 and then you have 4, which further makes it clear that if you are taking away the value or the full value or close to the full value of the asset, that's also expropriation.
7.4 is illuminating what the expropriation, term expropriation as defined in 7.1 is referring to. 7.3 is a freestanding entitlement for a shareholder to make a claim in that particular circumstance. It's not belt and braces for 7.1.
Well, that's your submission.
That's my, yeah. Now, the explanation, as we say, my lord, is both contextual when one looks at 7, but also when one drills down into the wording, what it's actually seeking to do is provide an entitlement to fair and equitable compensation, not to treat that binding action, I should say, expropriation of the local asset as a measure. That's not what it's seeking to do. Now,
there's been a lot of talk naturally about shares and companies. This clause actually goes beyond shares to different forms of investment in a company, including, well, it uses the term debentures or other rights of interest, but it looks as though that would include a creditor of a company. And it looks as though it's saying that a creditor of a company to which this kind of action or measure has been applied is also able to claim compensation. And it might be thought that's taking quite a broad view again of investment in a company. In other words, it goes beyond just shareholders, owners of the shares in the company. It's other people who are interested, if you like, in the economic fortunes of the company.
my lord, yes, one would have to read 7.3 and the nature of the interest in the economic fortunes with Article 1.1 to make sure that it's an capital I investment. So there are...
It probably is, isn't it? Because it refers to...
it does echo.
For example, in little 2,
Yes.
there's bonds, debentures, and then it goes on to say, and other debts and loans issued by an investor. And that would seem to be, in a company context, a loan issued by the investor to the company, to
Yes.
the business.
Yes, my lord. I think that is fair. As the significant point that we take from that is, notwithstanding that Article 1.1.2 has that potentially broader range rather than just shares, extends to other forms of participation. What this provision is not doing, again, this is just our submission, is treating the assets of the company themselves as the investment. So one may have a right or interest, whether it's shares, stocks, debentures, or as a creditor. That does not equate with a right or interest that qualifies as an investment in the assets of the company. That's why 7.3 was necessary.
Right, where does that take us to looking at the time?
My lord, I'm grateful. I have one more point on 7.3, which will take 1 or 2 minutes, with your indulgence. It's just to answer one point that... Maybe 2 minutes, my lord.
All right,
That's okay.
it's a 100% increase.
I do apologise for that. Obviously, my estimates are notoriously unreliable. My lord, just on 7.1, my Lord Justice Phillips asked a question or raised a point on direct or indirect measures. Can I just tell you what our submission is on that, what that means in 7.1? So, obviously, the provision starts with expropriated, dispossessed, or nationalised, expropriated, dispossessed, subjected to direct or indirect measures. See, nationalisation's taking over by the state, expropriation is a taking, dispossession is removing the owner. What's subjected to direct or indirect measures is essentially referring to is the effect on the investment. In both cases, the binding action has to be applied directly to the asset to be a measure. A direct measure in this context is likely an outright taking of the title to an asset, even if not labelled as a nationalisation, etc., but which has an equivalent effect. One example of that is given in 7.4, which is a compulsory sale of the investment. It is a measure because it's applied directly to the asset, and that we would say is what it's driving at. An indirect measure is one which doesn't take title to the asset away from the investor, but has an effect equivalent to that. And again, 7.4, an indirect measure would be, for example, freezing that asset in a way which effectively destroyed its value, again applied directly to it. So that's how we would say one can understand the wording in a sensible way. What it doesn't tell you is that an expropriation of the local company's assets is an indirect measure. What 7.1a is telling you is what an expropriation is. If the 7.3 situation, as I've said, was an indirect measure, it would already be an expropriation captured by the definition, and 7.3 is the argument of redundancy again. So that's our points on 7.3. Mr. Wordsworth has reminded me of one point that I just need to show your lordships, which is in relation to the EAIB case, for the proposition that 7.3 is essentially confirmatory of the position. If I can very briefly just show you that.
Just remind us where it is.
My lord, it's tab 12, please, of volume 1. Sorry.
Yep.
And just if one goes to the terms of the treaty, they start at page 135. And if I could invite the court to look at page 137. You'll see there, this is the expropriation provision, and your lordship should note that there's a similar provision in Article 4.3. So 4.1 is the general assets, investments must not be expropriated. etc. 4.3 is similar provision to the one that we've been looking at in 7.3. But what one will note here is that the parties have provided in 4.5 for a right to arbitration expressly within the expropriation.
I'm sorry, I'm afraid that you've lost me now. Where are you?
I do apologise, my lord. I'm at page 137 of EAIB, which is in volume 1, tab 12 of the authorities bundle. I apologise if I've given you a wrong reference. My lord, I was looking at this table, which is just a convenient place to see provisions. I'm sorry, I went too fast. So there's differences in the translations that which don't need, the court doesn't need to be worried about. But just using the right-hand side, the claimant's translation, similar provision to Article 4. Sorry, similar provision to Article 7 in our case. 4.3 is similar to Article 7.3. The point I was making was simply in Article 4.5 here, you have an express provision which provides that the investor shall have the right to have the amount of the compensation and method of payment reviewed by competent authorities of the state which prompted the expropriation or by an arbitral tribunal in accordance with Article 8. The only point I'm making in that context is that here you have a clear ability to bring a claim in investor-state arbitration for an expropriation. And the final point, my lords, is just in relation to paragraphs 323 and 324 of this judgment at page 150, where the tribunal in that case is looking at Article 4.3, and you'll see at page 149, I could invite your lordships perhaps to just read that. Yeah, they say at 323, just the final lines, the clarification provided by 4.3 in respect of such a case, that's for a minority shareholder, by no means compels the conclusion that assets held by a local subsidiary of which the investor owns 100% of the shares cannot constitute an investment under terms of Article 1.1. That obviously EAIB is a case where there's 100% shareholder but no equivalent to Article 1.8 as there is in our case, which we say is a fundamental difference.
Right.
My
Does
lord,
that
thank you.
conclude your
Yes, my lord,
submissions?
thank you very much
So
for
it's,
that.
it's over to Mr. Otto, is it? Very good. 10:30. Thank you very much.
All right, if able.